Welcome to day 2 of this conference on climate change and rule of law. We had an incredibly rich and diverse set of speakers yesterday. No pressure to anybody yet to speak in today's sessions. We have 30 more speakers and chairs. Yesterday was so full, so many really interesting questions for us to think about. I think many of us then collapsed into our beds at the end of the day. All I'm going to do is hand over to Professor Lisa van Haarle to chair our next session.
Okay, thank you very much, Stephen. I'm really delighted to be here and picking up and chairing this panel on climate change and the rule of law and the courts too. And I had an interesting interlude after yesterday evening session and the kind of first part of this topic. I went to the theater to see To Kill a Mockingbird, and it was a wonderful production. I recommend it. But of course, it was one of the kind of first pieces of literature, at least that I was exposed to, and I think many at that time are kind of questioning the role of the court and the role of rule of law in a socio-political landscape and system that was unabashedly unequal at that time. And I think yesterday's session raised really interesting questions about who comes out ahead in these court processes and processes of legal mobilization. How do lines of divide by race, class, disability, for example, affect the outcomes? Affect likelihood of getting access to justice. And of course, socio-legal scholars asking questions about legal mobilization, were much later than Harper Lee in some ways to start to ask those questions that are raised in To Kill a Mockingbird. And so I was thinking about all of these discussions that we've been having, we'll be having over these 2 days in that context. And of course, yesterday's panel at the end of the day was asking these questions about who comes out ahead and whether the haves do or not. And I think we also want to undertake rigorous examination of the outcomes of litigation and the recursive relationship between courts and the rule of law in a broader sense rather than just an instrumental one. So I think there are 2 sets of questions that unite the papers that we're going to be hearing today. One is about the role of courts in catalyzing or stemming responses to climate change. What does success look like and what does failure look like? And then a second set of questions is what does it mean to apply or uphold or enforce the rule of law in the context of climate change litigation? And so without further ado, I'm going to turn to our 4 speakers. And I have the unusual pleasure of chairing a panel of all online speakers, and we're here in the room. So this is a kind of new adventure for me and a reminder that we're still in a pandemic. We'll be hearing from 4 speakers. They'll each be speaking for 15 minutes. I think they can't see me, so I will be intervening to our speakers at about 17 minutes past to be prompting them to wrap it up at that stage. And that should leave us a good amount of time for discussion at the end. I know that we'll be wanting to have kind of lots of question and answer at the end of that set of presentations. So to turn to our first speaker, I would like to introduce Professor Gitanjali Gill from Northumbria University.
Once again, a good morning, and my presentation today focuses on climate change and the Indian judiciary through a transformative lens. Some introductory remarks before I really go into my presentation. Climate change, today's presentation, I'm focusing on climate change through sustainability transformative dialogue, which is underpinned by rule of law. And I take some examples from Indian jurisdiction as to how the judiciary has tried to interpret through transformative dialogue. Let me start by saying that India does not have a comprehensive climate litigation, though through several environmental acts like water, air, environment, electricity, energy, disaster management, they try to address the different facets of climate change. Climate change litigation in North and South are very different because there is a different sort of a mindset. And within the North, you have comprehensive legal and policy frameworks, and the climate challenges are also different. So looking at what the North is talking about, there is the human rights argument, alternative strategies against carbon majors, deceptive greenwashing marketing campaigns, and regulatory challenges to permits authorizing high-emitting projects. But Global South is different because there the climate change litigation usually is more in terms of the challenges that come up due to flawed regulatory and policy regimes, constrained political will, and constrained management of resources. But as what Lin and Peel talk about in their article, recent trends are showing that the use of climate language, human and constitutional rights, disaster management, resource conservation, and enforcement of environmental law and planning legislations are playing an important role. However, there's another trend which is emerging within the Indian judiciary, and that is interpreting climate through sustainability and sustainable development goals. In the year 2019, there were just 2 or 3 cases where there was a reference to sustainability or sustainable development goals. But 2020 witnessed a paradigm shift, and most of the judgments that are coming either through the National Green Tribunal or the matters which are going to the Supreme Court get a reflection of discussions taking place where climate is being read in light with sustainability and sustainable development goals. And that is why I'm trying to look into how climate is being interpreted, or climate litigation is being interpreted through sustainability transformative dialogue. Transformation towards sustainability has moved to center stage and is being increasingly institutionalized within global scientific and policy discourses. We pick up any report, 2021, United Nations Environment Programme Making Peace, 2030 UN Agenda for Sustainable Development, 2019 for climate change, biodiversity, and others. We see that the usage of word transformation, sustainability is really gaining traction. It's about transforming our world. It's a call to bring major transformations, integrating planet and people together for sustainable existence. Transformation involves fundamental changes, which include technological, economic, social, but also at the same time, it's bringing a change to the worldviews, norms, values, or governance. And sustainability transformation in today's time is increasingly being presented as a solution to environmental sustainability, including climate change and societal change. When talking in relation to climate change, sustainability transformation is asking for urgent and systemic societal changes that produce far-reaching solutions that meet the reduction targets. We are trying to envision a shift towards more ambitious mitigation and adaptation strategies, and that requires improved governance interventions. But these transformations which we talk about are not easy. This is a discourse which is more driven by Western school of thought, and within transformation, there are huge debates about whether we want a radical one or an incremental one. And particularly this question of transformation really becomes important for Global South. Which transformation? For whom are we talking about? And by whom is it being triggered by? High population densities and basic human needs create complex transformation challenges to reconfigure relationship between nature, people, resource consumption, and emissions. COP26 has really brought this thing into forefront, where the goal of net zero or decarbonization was being talked about, And the developing countries really put their point forward that it is anti-equity and resulting in climate injustice. But despite all these debates going on, scholarly debates going on, still sustainability transformation is considered as a way forward to solving the problems, essentially now in today's time, climate change and biodiversity. And it is here that it becomes important that there has to be a reorientation and restructuring of governance processes and actions. And my today's presentation specifically focuses on the strategic interventions that the Indian judiciary is making, though incremental, but trying to bring about cumulative structural changes. This is very important in developing countries. And the reason being that what we find is that the Westminster model is either fractured or it is ineffective. Look at the judiciaries that are coming from Asia, particularly India, Pakistan, Bangladesh, where the judiciary is really playing an important role in terms of bringing about changes to the lives of the people. And the argument that I'm making is that judiciary is acting as a lever of transformation to advance rule of law in climate cases by two ways. The first one is the traditional law enforcement and compliance process, wherein the power of legitimacy and high standards of accountability and transparency are important elements that influence sustainability transformation. So here, judiciary's contribution to the transformative agenda underpinned by rule of law is by bolstering environmental laws and policies and strengthening its compliance and enforcement. Therefore, the advancement of sustainability is dependent upon the effective implementation and enforcement of environmental, including climate laws. The second way through which the judiciary is trying to change, to bring a change is, as a lever of transformation is, change behavior onto a course of action that is very much focused towards sustainability by many small and strategic actions. And this, according to the UNEP 2019 report, is the ultimate goal of environmental rule of law. What this involves is implementing a powerful sustainability agenda that directs transformational change. A people and a planet-centered perspective, enjoying synergetic and holistic approaches, supports this sustainability transformation. The affirmation, adoption, and scaling up of sustainability decisions by the judiciary helps move towards a transformative change. And so the point which I'm trying to here make is that through this behavioral change, the rule of law is being advanced in order to bring about a change resulting in climate protection. And if we look to the climate change particular cases, we find situations where promoting sustainability agenda, the court has intervened into questions about good life and well-being, sustainable consumption and production patterns, values of responsibility, decarbonization, reduced inequalities, carbon taxes, market instruments, and technological innovations. Therefore, judiciary is acting, particularly in India, as a proactive and an incremental facilitator in actioning rule of law to further transformative agenda. By placing sustainability and sustainable development goals at the center of judicial making, what we are now seeing is a trend where the emphasis is by leaving no one behind, but simultaneously trying to ensure that climate is also being protected. In this context, let me take to what is India's position. Indian government at the international level claims that they are committed to tackle climate change. And they talk by three integrated transformative initiatives: low carbon shift, reconfiguring technology and institutional mechanisms, and third, mutually reinforcing policies. Unfortunately, at this moment, the policies are not very strong enough, leave aside a comprehensive legislation that is still not in place. But despite that, as everyone knows, Indian judiciary is known for its proactive stand. And within the climate, they are making step changes or small win processes, knowingly or unknowingly, consciously or unconsciously. And what they are trying to do is they are creating sustainable niches for an incremental but cumulative changes that helps in advancing a move towards transformation, which is underpinned by environmental rule of law. And when I was looking at cases, I have categorized cases in three kinds: climate conscious, climate accountability, and climate futurity. When we talk, yesterday we heard about climate conscious from a lawyering aspect, but today I'm talking about as to how, in a practical sense, the Indian judiciary is trying to make a change. Climate conscious is heightened awareness that helps us to understand, identify, and respond to root causes that generate and reproduce climate crisis. Climate conscious is a prerequisite to drive a transformational change. It is better to recognize the reality rather than the perception of an immediate climate threat. I use climate conscious in the broadest of sense to include that global climate problems with their local consequences through the paradoxical feeling of externalization and leave no one behind can make a difference. Externalization is a negative feeling of despair, and to be associated with the dialect of climate destruction creates a crisis of consciousness, and it also serves as a motivation to bring about a change in that regard. To be conscious is also to be conscious of one's death. So knowledge of our death also brings about a transformational concern. On the other hand, leave no one behind is a hope of positivity. It is all about SDGs, which are based upon integration, indivisibility, and universality. It raises awareness and hope that climate sustainability implies that we need to heal and secure our planet and shift our world to a sustainable and resilient path. Thus, climate conscious, through conflicting emotions, builds up a wish for a collective action. In this context, judiciary can and do play a useful role in developing the law and contributing to climate consciousness, thereby leading to these developments, catalyzing into new and needed actions, as what Professor Philippe Sands talks about, making the states, international organizations, private sector, NGOs, individuals aware about their responsibilities and actions. This in turn creates security, stability, and willingness to develop and accept law that promotes climate sustainability course thereby building legitimacy both in the judiciary and in the rule of law. Some of the one of the
Geeta, sorry, I'm sorry to interrupt. We're going to have to wrap up in about 2 minutes.
Okay.
So I'm just conscious of the time.
Yeah, okay. So we have cases in Jaisima versus Government of Delhi, and where this kind of consciousness was being raised because there was a direct connection which was being made in relation to how there is a need to develop these guidelines which would be helpful. Climate accountability is another one, which is a traditional one, where you're holding the actors responsible for the decisions that result in greenhouse gases. And in doing so, there is an emphasis on process as well as outcomes. Processes are including actions where, through rule of law, public authorities are made accountable for their actions, whereas outcomes are making sure that you are moving towards creating sustainable agenda in light with sustainable development goals. And this 2019 case has really changed the way things are bringing about in India, because it is here that the Supreme Court judge is trying to say that we need these transformative changes in order to bring about transformation sustainability, which will be underpinned by rule of law. And the last one I'm going to talk, because of time paucity, climate futurity. It is very crucial for transformation towards sustainability, because it is mediated by the rethinking of our relationship with nature and requires an imaginative extension. How we are going to have a meaningful debate. And the rule of law in this case is trying to change a course of action by making sure that we try to introduce sustainability niches within the thinking processes for climate change. And in this context, sustainability vision within India is talking about low carbon initiatives to reduce greenhouse gases, zero carbon programs, promoting non-coal fuel resources, renewable energy. To sum up, I would say climate change, we know, causes irreparable consequences. But in today's time, this is an alternative way of looking into how we can build our responses. So transformation towards sustainability can provide us the way forward. But in Global South, this is all through incremental steps. And the Indian judiciary is playing a very important role through a collective vision of a sustainable future, which is underpinned by rule of law. Because the ultimate goal of rule of law is not only with the compliance of laws, but also to change behavior onto a course towards sustainability. And that is where these new developments which are coming in the form of climate conscious, accountability, and futurity are really becoming important. Judicial contribution in countries like India, where we feel there is an ineffective legislative or executive action, plays a very important role to ensure that climate is protected, while at the same time, sustainability and sustainable development goals are also being given legitimacy and credibility in this regard. Thank you.
Thank you so much, Geeta. A really fascinating start to our panel. Interesting questions of kind of the governance gap and the way that an activist judiciary can step into that. So I'm sure there'll be questions that we'll come back to at the end. And this role of kind of that courts play in the rule of law, in the construction of legal concepts and kind of being at the cutting edge of that, I think will also be a theme in the next paper. I'd like to introduce Professor Liz Fisher from the University of Oxford.
Thank you so much, and thank you to the organisers for what has been a really fantastic conference. So let me get started. It is a legal truth, grudgingly acknowledged, that many climate change cases in common law jurisdictions are cases about statutory construction. I say grudgingly because statutory interpretation, I think we think of as too basic. It's too much introduction to the legal system 101. It also seemingly makes climate change adjudication too context specific. And perhaps more specifically, as common lawyers, we tend to think of legislation as a kind of interloper into the common law. As Martin Krieger said over 30 years ago, contemporary statutes are believed to be examples of the differentia specifica of modernity and anti-traditionality in law. But what I want to do in this presentation is I want to look at these statutory construction cases, and I want to show how they highlight that in actual fact, climate change adjudication is far more legal than we often think it is. So I want to do 4 things. First of all, I want to give an overview of some of these cases, looking at the UK, Australia, and the US. I then want to highlight the fact that these cases are about statutory interpretation is not surprising for 3 reasons. I then want to discuss the kind of legal expertise that these cases highlight we need. And finally, I want to reflect on the implications for legal scholars thinking about their mental constructs when it comes to law. Okay, 3 caveats. The first is this is a paper obviously about the common law. Secondly, this is a paper that takes an internal account of climate change adjudication. And that's why I use the language of adjudication, not litigation. Lisa raised some fantastic questions in her introduction. My paper's not going to look at them at all. And finally, and most importantly, this is a work in progress. So any feedback I would really appreciate. So first of all, statutory construction in climate change cases. And here, let me start with a confession. Last year, my colleague and I wrote a case analysis on the Heathrow decision in the Supreme Court. And my confession is this. We'd already published a case analysis on the case in the Court of Appeal, but when it went to the Supreme Court, it was a very different case. In particular, the only legal arguments before the court were climate change arguments. And it took me 1 month and 5 read-throughs of the case to realize something which is very obvious about it. The case is not so much about climate change, but it is about, to use the language of Scotford and Minus, the language of, it is a case about the direct and indirect climate change legislative obligations. What I mean by that is in the case, the court was being asked legal questions in relation to direct climate change legislative obligations, i.e. legislative obligations in the Planning Act, which specifically regulated climate change, and action under the Strategic Environmental Assessment Directive, which might have. Now, the fact that it took me a month to realize this is not really that surprising, because what we found, Joanna and I found striking, is that not many other people saw the case in that light, even though if one surveys climate change case law, most of it is about legislation. And just to give one example of a statistic of that, the Sabin Centre's climate change case chart for the US, as of the 29th of March, of the 900, there are 959 cases in that chart, which are to do with federal legislation in the US, as compared to 86 constitutional cases and 54 common law public trust cases. And a similar pattern can be seen in a rough survey I have done of UK cases. Okay, so in being cases about legislation, what are these cases about? Well, in my kind of survey of these cases, it seems to me that the questions about statutory construction fall into 3 different categories. The first are those cases where what is before the court is a classic legal question of how to interpret a legislative term in a statute. And that might be a legislative term which is explicitly about climate change, a direct legislative obligation in Scotford and Minus's term, or it might be the question of whether a legislative term can accommodate thinking about climate change or taking action in relation to climate change. The classic example here is CO2 a pollutant under the Clean Air Act in Massachusetts and EPA. The second category of cases that we see in in relation to statutory construction is cases about whether policies, and it's interesting, and I'll come back to that, or decisions made pursuant to a direct or indirect legislative obligation discharge a legislative obligation. And these are cases which administrative lawyers might classically think of as irrelevant, relevant consideration cases, or what is a material consideration to be taken into account. And the question here is how and in what way does legislation frame discretionary power? What is included in that power and what is not included in that? So just to give you one example of that, in the Heathrow case, the question was, what did Section 10 of the Planning Act, in its reference to the desirability of mitigating and adapting to climate change, have regard to? And I could give many other examples. And the final category of cases involving statutory construction that we see in these cases I usually relate to obligations of environmental assessment and whether they include consideration of climate change. So within different regimes, there are duties to assess environmental impact, strategic environmental assessment, what was in the Heathrow case, environmental impact assessment, and other variations. And the question is, does looking at this legislative regime and the language of it and the context of it, does it require consideration of climate change? Okay, so they are these three different categories, and I could bore you senseless with examples from the cases, but I won't. Let me now move on to my second point. There is nothing surprising in this for three reasons. First of all, as any administrative lawyer knows, statutory construction is at the heart of the subject, and these cases can be simply seen as a continuation of this. And for the sparky administrative lawyers in the room, you will notice that my three categories map onto three classic ways of thinking about the grounds of judicial review. The second reason why the centrality of statutory construction is not surprising is, of course, statutes are a feature of environmental law. The very important work of Eloise Scotford highlights this in a really important kind of way. And so these cases in many ways can be seen as a continuation of case law in environmental law more generally. Third, the reason why these cases are about statutory construction of climate change relates to climate change itself. Now, on the one hand, climate change is a hard-edged physical fact. It is about physics. But as a social fact, that is where, in a sense, there needs to be choices about how do we frame it. It's a collective action problem, it's uncertain, it's polycentric, it is different from other types of legal problems. Choices need to be made about how we are going to make sense of it. And legislation will frame those choices, and interpreting legislation will require choices about how we are going to frame climate change. And just to give you a couple of examples from the case law, if we take again the Heathrow case, the question in relation to Section 5(8) of the Planning Act that account the reasons needed to take account of government with a capital G policy relating to the mitigation of and adaptation to climate change. The question is, well, what does that mean when you have a polycentric, multi-level, global kind of problem? And again, I could give more examples, but I can see the time. Okay, so moving on to my third point. What does this highlight? Well, first of all, it highlights that when we look at these statutory construction cases in climate change, we are highlighting the importance of legal expertise in climate change adjudication. These cases are not so much about a purposive or a literal interpretation, but as Andrew Burrows, who is now on the Supreme Court in his book on statutory interpretation, stressed, the question is, what is the best interpretation, taking everything into account? And as Lord Justice Sales, as he was then then was says about this: statutes are legal instructions transmitted into an existing highly developed framework of legal values and expectations. The existing law, modes of reasoning and established localized value systems provide the interpretive context in which a statute is read. Upon receipt of a statutory text, lawyers and the judiciary seek to knit it into the fabric of law. And that is very much a legal enterprise, although, and I'll just pause on this point briefly, it requires also an interactional understanding of the complexity of climate change. Okay, so let me now come to my final point. What is the implications of everything that I have just said? As I said in the introduction, legal scholars, not so much practicing lawyers, but legal scholars tend to think of legislations as an interloper into law. The language used is often quite powerful. Statutes swallow the common law. Lawyers choke on them. It's all very negative. But we also tend to think of statutes as kind of alien to legal reasoning. Roscoe Pound, back in the mid-20th century, talked about them as imperatives. Nigel Simmons have suggested that the interpreters of a statute can easily become technocrats. But, and this is where I end, there are three things I think are highlighted from this analysis. First of all, these cases, in a sense, confirm what judges have been telling us in their lectures for years. Legislation is really important and working with it is very legal. Secondly, and this I think is a really interesting point, is that actually these cases are not so much about a purposive or instrumental approach to law. They are, when you read them, about how do we ensure the stability and the integrity of legal reasoning in light of a new problem. And finally, and perhaps more importantly, the elephant in the room over the last day, and I suspect will continue to be today, is that in actual fact, we think climate change adjudication is not legal. And I hope by looking at these cases, we can see that it most definitely is. Thank you very much.
Thank you, Liz. Very provocative, and I'm sure that will come up in the question and answers. Thank you so much. I think we're going to move straight on. Good evening, Professor Jackie Peel, who'll be speaking to us, I believe, from University of Melbourne.
It's a good evening from me in Australia. You can hear me okay?
Yes, it's great. Great to see you, Jackie.
Can. That's great, and great to see you there. I'm sorry I can't be there, but I have to say the doors of Fortress Australia have only recently opened, and it is great, I guess, that I can still join you online, and it does have the benefit of far less carbon emissions than me travelling to be with you. I'd like to, because I am presenting from Australia, acknowledge that I am speaking today from the lands of the Wurundjeri Woiwurrung people of the Kulin Nations, and pay my respects to their elders past and present. Indigenous knowledge is a key part of our climate knowledge and learnings here in Australia and in many other countries, and is coming to the forefront of climate litigation increasingly as well. I'm going to share my screen. I really enjoyed listening to Liz's presentation and also Geeta's before me. I'll try and keep my presentation fairly brief because I would be interested to hear the discussion and some of the thoughts on ideas that came out of the presentations before. I've entitled my presentation Recipe for Success in Strategic Climate Litigation, which I guess is responding to Lisa's prompt at the beginning of the session about the extent to which we might be using courts as a tool for advancing climate action, with attention particularly to what outcomes we might see from litigation and how they're taking forward positive climate action. So that's how I'm going to frame my presentation. And this is based on a paper by myself and Rebecca Markey-Towler, where we compared a number of case studies to try and draw out, if you like, some of these questions around success in climate litigation. So I've gone too far. I want to start though with a definition. You'll be glad to know, not a definition of climate litigation, because I think we've been around that particular block many times before, but more with the idea of what we might mean by strategic climate litigation. I'm not entirely sure I've got these ideas right, so very interested to hear people's feedback. But I feel like in the last 5 years or so, people have started using this term a lot more, and using it in a way that seems to accord perhaps with more socio-legal understandings, Lisa, talking about the use of the law as a tool in combination, usually with other non-legal methods, extending beyond court action to seek legal, policy and social change. And in fact, I'd say one of the key factors that we've seen in evaluating climate litigation in terms of its success has been that it's often more effective where it extends beyond court action and encompasses a relationship with non-legal methods like campaigns. In strategic cases, as Joanna Setzer and Catherine Hyham have talked about and others, litigants are often motivated by concerns that go beyond their own individual circumstances and aim to achieve broader outcomes. And I think we can contrast this with more traditional uses of litigation where the issues primarily relate to the parties involved, who might be seeking to right a wrong, or to secure a legal remedy or enforce existing laws. So after listening to Geeta's presentation, I wonder if I need to recast that understanding as well. So one other thing that we know is that when we look at the statistics, which are assiduously compiled to our great benefit by many people now, including the folk at LSE, we're seeing strategic climate cases on the rise. The graph on the left-hand side shows the trends as discussed by the Global Trends in Climate Litigation updates that are produced regularly by LSE, with the percentage of strategic cases increasing markedly outside the US over the last couple of years. We've done a similar analysis of the Australian climate litigation. Australia has the second highest number of cases, so it provides a decent case sample to look at in this regard. And again, we see this uptick in what can be described as strategic climate cases. So there's something happening here that is a trend that's worth paying attention to. The questions that we've had are these cases successful? What outcomes are they achieving, and what does that demonstrate about the role of courts as part of governance processes to address climate change? So that immediately raises the question that Lisa also highlighted at the start of the presentation about what is success. And I'm sure that there'll be as many definitions and understandings of what success is. I'm just going to offer you a few different ideas from the work that we've done. Obviously, you can have impacts from litigation that are both positive and negative in terms of your ultimate climate goals. So hopefully success in some instances involves a positive movement towards change, where we can see results or outcomes that take forward climate action. I think success is also often, in this context, impacts that extend beyond the courtroom. Liz made a very passionate plea in her presentation just before for the importance of paying regard to statutory interpretation and legal processes. I think in strategic climate litigation, we're often looking for how those legal interpretations ramify beyond the courtroom, in direct or indirect ways. We've usually used the term indirect to talk about impacts that are longer term impacts or effects, and usually less directly causally connected to a particular case or judgment. On the right-hand side, the graph itself is not going to be terribly meaningful, but it was taken from a study we did recently for the Children's Investment Fund Foundation. Unfortunately, not yet published, but will be, where we were looking at across the literature at the extent to which the literature itself had something to say on the indirect effects of climate litigation. And we categorised the different kinds of effects, including whether the case was bringing about behavioural change by government or corporate actors, whether it was setting a precedent that was being copied elsewhere or inspiring similar litigation, whether it was changing the calculus of risk or cost associated with a particular course of action, for example, by causing delay to fossil fuel projects or increasing the cost of doing business, or whether it was bringing about broader social change, including inspiring social movements. So those were some of the sorts of impacts that we were looking at when we were talking about the impacts of strategic climate litigation. So the particular paper that we developed was cheeky enough not just to define what success might be, but to suggest that there might be a recipe for getting there. And feel free to violently disagree with me on these different categories that we've put forward. But the basis for trying to discern this kind of recipe was twofold. One was that we thought we might look at very high profile cases that had generated a lot of interest in the literature and the broader media commentary, like Newbar, Shell and Sharma, and think about if there were common features that seemed to point towards their relatively successful outcomes. And the other thing is that we're intensely aware in our practice-based work that funders of litigation, supporters of litigation, are very interested in whether there is such a recipe in existence so that they can replicate it and direct funds towards these sorts of cases. So these are some of the things that we had highlighted. In the interest of time, I won't go through these in enormous detail, but just to say that we thought there was something in the types of plaintiffs that were selected, particularly creating stories around plaintiffs that could help amplify a strategic message, using experienced legal teams with a track record of bringing other strategic climate legal interventions who have practiced with that combination of combining a legal case with non-legal tools, targeting defendants who were laggards, in a sense giving you the bad guy against the good guy in any strategic climate litigation story, tying legal arguments closely to the latest climate science, with the IPCC science emerging as a kind of touchstone for understanding key concepts like carbon budgets and the urgency of the task of mitigating and adapting. Often these cases have very innovative legal arguments, including those emphasising duties of protection. But I have to say, in other writing that I've done, I've also called out the importance of cases that achieve incremental change and rely on methods more like statutory interpretation. So it's unclear whether this is a key element. But remedies in these cases are usually framed in ways that allow them to extend beyond the situation of the individual litigants and to contribute to intended policy and regulatory impacts. So finally, I just want to say something on an Australian case that we've seen a recent decision in, which in our previous Recipe for Success article, we had been touting, at least at the first instance, as an instance of successful climate litigation. This is the case of Sharma, where a group of young people in Australia, all representing themselves and all kids under 18 in Australia, sued the Minister for Environment, the Federal Minister for Environment, arguing that in approving an extension to a coal mine, essentially she had, running alongside her statutory powers, a duty of care to prevent personal injury through climate change impacts to these children. It was a win at first instance and had very interesting ramifications and legal ripples through the Australian legal system, and I think beyond. But just a couple of weeks ago, we saw the duty unanimously rejected on appeal by the full federal court. My colleague Beck Markey-Tao has written a blog post that really summarises the complexity of 282 pages of judgment by 3 different judges in that case. But it's also required me to reflect a little bit on what successful litigation looks like, and to revisit the idea that sometimes when we seek to use the courts to push for positive change, we have to be aware that a negative outcome in a legal sense can also have very severe ripple effects through the system. And my overall assessment of the Sharma judgment is that it is potentially a very significant break on litigation, climate litigation in Australia, even though there is a lot of sort of soul searching going on at the moment in this country as to whether there are other avenues that are still left open by this decision. So one of the key questions, or one of the key findings in the judgment, particularly by the Chief Justice here, was an argument that's been echoed many times in climate litigation around the world, which is this really an area for policymakers that the courts shouldn't be attempting to intervene in? So that's not a terribly positive note to land on, but I think an important note to sound in this discussion around the role of courts in climate litigation. So Lisa, I'll stop my presentation there with my fancy slide on all of my other role at the moment within Melbourne Climate Futures, and really interested to hear the discussion and questions. Thank you.
Thank you so much, Jackie. That's really fantastic, interesting work, and I know your work is really influential on this and kind of shaping decisions about funding and strategy, and so really look forward to kind of getting into all of that. We do have one more intervention, which I believe is a recording. And this is Professor Carrie Warnock from the University of Otago, and she'll be discussing the principle of legality, normalizing climate change considerations in litigation, and then we'll make sure that we have lots of time for discussion after that.
Thank you to the organisers for inviting me to present at this important conference. I want to talk about a symbiosis between climate change and rule of law considerations. That is the linkage between climate change, fundamental rights, and statutory interpretation. And the title of my presentation is The Principle of Legality, Normalising Climate Change Considerations in Litigation, ? Last month, 22 people lost their lives in the eastern Queensland floods. That there is a clear factual and legal link between climate change and the abrogation of fundamental human rights is no longer conjecture. Rather, it is being affirmed in jurisprudence around the world. Climate change provides the factual context, but the breach rights focused upon include the right to life, the fundamentals of life, and the right to private property. Now, many of those cases are based on breaches of justiciable rights in codified constitutions. But this development raises an intriguing possibility for lawyers in New Zealand and the UK, both common law nations without codified constitutions. Could that climate change rights linkage inform statutory interpretation? And by doing so, ensure climate change considerations infuse the wider law in those nations? There are two possible legal routes for this infusion to occur. Firstly, both the UK and New Zealand have statutory bills of rights that require courts to interpret legislation in a manner consistent with the enumerated rights where possible. In New Zealand, we have Section 6 of the New Zealand Bill of Rights Act 1990, NZ Bora, and you of course have Section 3 of the Human Rights Act. Secondly, senior appellate courts in both nations draw on the principle of legality in interpreting legislation to protect fundamental common law rights. In this brief presentation, I just want to focus on the possible role that the principle of legality might play, for good reasons, as I explain towards the end. The principle of legality, of course, is a presumption of statutory construction that protects common law rights and norms against general or ambiguous legislation. The courts presume Parliament would not propose infringement in the absence of irresistibly clear statutory language. In practice, the principle enables courts to give words their least rights infringing meaning, to read down literal meaning, and to make statutes subject to some unexpressed qualification. The principle of legality can arise in any statutory context, including criminal, administrative, and even private law. In the UK, the principle is of ancient pedigree, emerging in the 1600s, crystallising in the mid-1800s, and being supercharged after Sims in 2000, wherein Lord Hoffman stated it was a presumption of general application, operating as a constitutional principle. But of course, the principle of legality is used in common law jurisdictions around the world. The High Court of Australia has described the principle as a central aspect of the rule of law in that nation. And in the case of Fitzgerald decided last year by the New Zealand Supreme Court, Chief Justice Winkelman stated that the principle was not displaced or confined by statutory bills of rights, but continues to develop. So how could the principle of legality help cement the link between climate change, fundamental rights, and statutory interpretation? Well, with the link between climate change and fundamental rights firmly established in many jurisdictions, can we now propose that to protect rights, courts should prefer legislative interpretation that promotes limiting emissions or fostering adaptation to climate change where possible? Now, this suggestion might seem rather abstract or even frivolous, so I want to explore the idea with an example. And that concerns the case of Genesis and Greenpeace, heard by the New Zealand Supreme Court in 2009. Now, the applicants, Genesis Power, wanted to establish a gas-fueled power station that would emit millions of tons of greenhouse gas over its lifetime. The relevant legislation creates a statutory presumption against industrial air pollution, so the applicants would have to apply for a consent to pollute. Before doing so, they sought a declaration in relation to the meaning of Section 104E of the Act, a tortuously drafted section that sets out criteria for decision makers. For our purposes, the particularly troubling wording was, when considering an application that would emit greenhouse gases, a consent authority must not have regard to the effects of such a discharge on climate change. Now, those words clearly constitute a prohibition, but what are they prohibiting? There are two conceptually distinct meanings. First, an activity's climate change forcing impact should be disregarded, the result being that fossil fuel will be a neutral consideration in the consenting decision. The second is that the decision maker should not undertake an exercise seeking to assess the effects of greenhouse gases on climate change, i.e. they shouldn't get into debates about whether greenhouse gases actually lead to climate change or how this particular activity's emissions would impact the climate, which, as the Chief Justice pointed out, will be impossible to do. 9 appellate judges have considered this section, some of them more than once, and there was a divergence of views. In the Supreme Court, the majority found in favour of the first meaning, that the climate change forcing aspect of the proposal, the elephant in the room, so to speak, must be ignored by the decision maker. But in dissent, the Chief Justice found in favour of the alternative and opined that consent authorities must consider an activity's emissions and their impact on climate change as a negative factor in the consenting process. Now, that case was decided firmly within the four squares of the statute, on the statutory text, and with some consideration of the legislative history. Although the diametrically opposed conclusions that the majority and the minority came to made that process of interpretation look a lot like judicial whim. Counsel did not advance, nor did the justices invite submissions on wider doctrine. And there was certainly no suggestion at all of this being a human rights issue or of impacting fundamental norms and values of the common law. But what we know now, given the clear linkage between climate change and human rights, what would have happened if the principle of legality had been used to present a rights-based argument to the court? If Greenpeace had argued, when the text of a statute presents constructional choices, The principle of legality will favour the choice which least disturbs common law freedoms. That the statute should require the consent authorities to consider, alongside other criteria, greenhouse gas emissions because their impact on climate change imperils fundamental human rights. Now, the Greenpeace case provides an obvious example of this type of analysis, but might this analysis be of wider reach? Well, contextually, of course, it would apply whenever climate change exacerbation, mitigation, or adaptation is an issue. And in the New Zealand context, I found examples of legislation that might be susceptible to a principle of legality analysis. Legislation concerning planning and special planning legislation, infrastructure investment, conservation law, companies law, even criminal law. Now, public lawyers might look at that list and will no doubt ask, what conceptual work is the principle really doing here? Not all, but many of these decisions will be made by the executive or constitute public function decisions. Accordingly, they are subject to direct duties under NZ Bora and the Human Rights Act to uphold statutory rights, and a failure to do so may well found a basis for judicial review. Further, Section 6 of NZ Bora and Section 3 of the Human Rights Act require the judiciary to interpret all statutes in accordance with the statutory rights contained in those acts where possible. Well, I would suggest that there are 4 reasons not to overlook the possible role of the principle in bringing climate change impacts into statutory interpretation through rights protective construction. Firstly, the judicial embrace of a re-emerged principle of legality provides a means of non-regression, preventing any rollback on statutory rights protections, i.e., in the event of Section 3 of the Human Rights Act being repealed, the principle of legality assumes heightened importance. And of course, see the current proposals in that regard. Second, the principle of legality has wider scope than statutory bills of rights, expanding upon the suite of rights protected under those acts. And it protects rights that might be important in the climate change sphere. For example, clearer scientific opinion exists in New Zealand as to the adverse impacts of climate change on property, what, where, how property will be impacted, rather than concerning the loss of life. And the right to private property is a fundamental common law right, protected by the principle of legality, but not the statutory Bill of Rights. Thirdly, classical versions of the principle of legality have organisational force in legal reasoning. To quote Gans writing in the Australian context, the principle's rule-like operation permits courts to make exceptionally clear statements about why they opt for a particular reading of a statute. And think again about the Greenpeace case. Drawing on the principle of legality may have provided the capstone for legal reasoning to coalesce under and provide the clarity lacking in that decision. But by far the most intriguing aspect of the principle of legality concerns the question of proportionality. Should the principle of legality methodology incorporate proportionality? Now, classically, the principle of legality did not incorporate a proportionality test. In contrast, statutory bills of rights provide reasonable protection for rights. That is, they contain limitation provisions that direct courts to consider the legislative policy behind the rights infringing statute. And if it's justified, apply the transgressing text regardless. Justification is tested against a particular measure or standard, i.e. proportionality. Now, the courts have not grafted a proportionality test onto the principle of legality in New Zealand, nor in Australia. The principle is employed to determine the legal meaning of a statutory provision, not to evaluate whether a policy choice to abrogate rights could be justified. And as Dan Meagher has argued, A proportionality inquiry is of necessity context and case specific. And further, it would obscure the common law rights that Parliament is supposed to be cognizant of in legislating. But of course, we see a very different approach in the UK, where the Supreme Court has developed the methodology of the principle to include proportionality in administrative law cases. Jason Varohouse terms this an augmented principle of legality and notes it's provided greater protection for rights in some cases. For example, where the legislature has provided clear and express words abrogating access to justice rights, the UK Supreme Court has applied a test of least intrusive means. In the prisoners' cases concerning delegated legislation, general words that would require deference in substantive review are susceptible to a principle of legality analysis without deference, because statutory interpretation is for the courts, not the executive in the UK. Now, differences in content and application of the principle evidences the importance of legal culture, and the approach of the UK Supreme Court may, of course, well reflect changes post-Brexit. But the type of right in issue is also important. In the climate change context, we can imagine that proportionality would create the analytical pressure point. Is the rights infringing provision proportional? If proportionality was the test, we might see the usual hurdles erected and the arguments raised that climate change is a polycentric social policy issue with a balancing test best left to politics. It's possible that considerations of justification and proportionality may not be so protective of rights in the climate change context. Proportionality is, of course, complex, but suffice to say it is a matter of some general academic debate as to whether the principle should be subject to proportionality at all. Conclusion. The principle of legality undoubtedly raises fundamental questions about the rule of law, and it's trite to state it brings into stark relief the tension between constitutional theorists and reignites arguments about the indeterminacy of rights. Its use in the climate change sphere is likely to create resistance from the powerful sectors who profit from pollution. And of course, there is a risk that it could be weaponized by those entities. There are also very specific doctrinal debates about when the principle should be engaged, the specific rights it protects, its scope and content. Should these questions and debates prevent the principle of legality being raised and carefully debated in statutory interpretation when climate change impacts on rights are an issue? Arguably not. We're at a moment in time when rights are not only at risk, but lives are being taken by climate change. And it will be legally and perhaps constitutionally wrong if the judiciary did not consider seriously arguments linking climate change, the abrogation of fundamental rights, and the construction of statutes. Ngā mihi nui tēnā.
Great. I think we're going to wrap up there. Please join me in thanking our wonderful set of speakers. And we're continuing straight on to the next session, so please don't go anywhere.